Welcome once again to my channel. My name is Msimi Alex, and basically today I'm going to guide us on land transactions and basically what also we call landlord too. And basically today we want to talk about what we call termination of leases and how leases terminated. Under what process? What can we infer from and say that the lease has been uh, terminated? That's a very, very important. Otherwise, before we proceed, I want to remind you that we have videos on this very channel about leases, creation of leases, uh, different categories of leases. We have videos on essential elements of a lease where we discussed them. We talked about certainty of time. We talked about exclusive possession in the depths of them. So take time and look out for those videos. They will actually shed more light on the same. Let's now delve so deep into our today's discussion. We want to talk about termination of leases, basically termination. How does a lease come to an end? And number one is what we mean by expiry. A lease can expire. For example, this is as simple as you can hear it. The moment you had, let's say, people, a person, the lessor and the lessee had a lease of 40 years. When 40 years end, when 40 years lapse, then that's automatic cancellation of the lease. That is automatic termination of the lease. That is very, very important that we must appreciate. The moment persons had, let's say, a lease of 20 years, and if 20 years end, then a lease comes to close. That is what we call by expiry. So the moment you appreciate that, then now we switch to what we call notice. How is a lease terminated by notice? A notice, this is basically where uh, the lease is still, it has not yet reached its end, it has not yet expired, but one of the parties wants to end the lease. Then you must notice the other person that actually you want to end the lease by serving him with notice. And the notice is served within a specific time, so it is always before it's always before the date or the real time that that lease is to be terminated. It is important to note that a notice must be served to a lessor if it is the lessee that wants to terminate. It must be served to the lessee if it is the lessor that wants to terminate. Or it can be served to the agent of that person to whom it was directed to. If it happens and it is served to a different person, then that does not amount to termination of the lease. That is very, very important. That means you have to appreciate the decision in the case of Lennon versus Londem. Lennon versus Landem, actually, it's the Landem. In that case, it is the wife that owned the property. She had rented it to an individual, but the husband to this wife served a notice of termination to the lessor or to the tenant. And of course, the tenant contested about it or objected it, and court observed that the husband did not have any rights to terminate the lease because he was not the owner of the property. He was not a party to that lease agreement. Therefore, the service was not effective because it was served by a wrong person. That is very, very important. Still, when you look at the decision in the case of Barry versus Penesa, it's a case of 1972, East Africa, at page 94. The same thing comes into play. But for here, this was an advocate. This was a lawyer who served a notice of termination to, on behalf of his client, and court held that service or that notice was effective because it was served by an advocate who was actually an agent of the client or of the landlord, and that is very, very important. All this comes to tell us that if a person serves a notice, but that person is not supposed to serve it, or is not the holder, or is not serving it on behalf with authority, then that service does not take effect. That is very, very important. Of course, now we need to go on and appreciate another category of how basically it can be terminated, of how basically a lease can be terminated. And that is basically what we call forfeiture. Forfeiture, basically what is it? What do you need to understand about it? Forfeiture, here basically someone re-enters the property of his property, but because it was in possession of another person, of the tenant, but the landlord re-enters, takes into possession of that property before the end of the lease, before the end of the period of that lease. That's what we mean by forfeiture, and it is mostly in cases where the tenant has breached maybe some terms of the lease agreement. It does not just happen, but it is in most cases where a landlord, maybe by implication, there is a possibility that this tenant will breach some terms, or this tenant has already breached terms of the tenancy agreement. So there can be what we call forfeiture. And of course, to that effect, you need to appreciate the fact that there is always parties may agree under the lease agreement that that the tenants will be forfeited depending on specific terms. That, for example, if a tenant maybe fails to pay the rent, or if a tenant maybe fails to do, depending on the terms of that agreement, you can still include it under that agreement, that if so and so happens, then the landlord will have a right to forfeit the tenants. That is very, very important. So you need to know that re-entering into possession of these premises, it is okay, but it is always advisable that before you re-enter into possession of that rented land, you must have a court order to avoid someone bringing an action, maybe that you trespassed into his rented property. So it is always important that you have a court order allowing you to re-enter that land or that property or that premises. That is very, very important. So of course, you it is also advisable that before you re-enter into possession of that premises, you give notice. You must give notice that, please, actually, not only notice, if let's say someone breached in or defaulted in payments, you must have served that person with a demand notice, and he could, maybe he also failed to adhere to that demand notice. He also faulted that demand notice. That is when you can forfeit the tenancy. Otherwise, he can sue you for breach of the tenancy agreement. So the moment you see that there is a problem with that tenancy, instead of just jumping from nowhere and you take into possession, or you re-enter into possession, it is advisable that you first serve that person with a demand notice, then you proceed and have a court order allowing you to take into possession or to take on your land or your property. That is very, very important. So you have to actually look at the provisions under section 25 of the Judicature Act. It also provides how it provides for the relief when actually the landlord sues for re-entry into land. There is a relief provided for under section 25 of Judicature Act. Look out for that provision and appreciate it, it will actually shed more light to that effect. Let's now proceed and talk about another category under which a lease can be terminated. There is what we call surrender. And what is about surrender? Basically here, it is a period before the close of the tenants. Before the close of the tenants, or before the tenancy ends, the tenant decides to give out his rights, to surrender, to say, no, take your property, I no longer want to proceed with this tenancy agreement. I no longer want to be a tenant here. I've given up. That is basically what we mean by surrender. It is always before the expiration of the lease agreement, of the period in the lease agreement. That is how it comes about. And basically, that is what we mean. And when you want to appreciate what basically it means by surrender, I will also have to remind you that you need to look at the provisions under Section 107 of the Registration of Titles Act, where it provides that actually a lease may be surrendered by endorsement. That a lease may also be surrendered by endorsement. That is very, very important. And you need to know that surrender can be either by agreement or by operation of the law. That is very, very important. Or it can even be by the statutory provisions. For example, if a very good example to this effect is when when the landlord, you already have a tenant, or you are already a tenant, or you already have a lease agreement, a lease moving on. Then a landlord comes in and offers to give you that you enter into a new lease agreement, and then you accept. It means the other one had not ended, and now you're bringing in another one. That means the other one will have been surrendered, and you entered into a new one. That is very, very important. Or it can be where the tenant abandons the property, abandons the rented property. For example, someone had a lease, maybe has been in the house, but he abandons it before the expiration of that time, of the specified time. Then that means that it has been surrendered. That is basically what we mean by surrender. Okay, so you will allow me now to take you to what we call merger. Merger is also another category of termination of lease. And merger, basically, we are dealing with two things. There's what we call a reversionary interest and leasehold interest. A leasee holds what we call leasehold interest. Then the landlord holds what we call reversionary interest. Please appreciate this. A lessee holds what we call leasehold interest. Then a lessor holds what we call reversionary interest. And how does merger comes in? The very good example here is when the landlord decides to sell his reversionary interests to the tenant. For example, you have the land in Mukono. Someone is renting that land. Someone leased that land. But you also decide to sell that very land to that very person who is renting it. That's basically how merger comes in. It means there will be merger of reversionary interest with leasehold interest. And the important to note here is that merger will not take effect. There shall be no merger if reversionary interest and leasehold interest are not given to one person in the same right. So in short, for there to be merger, both reversionary interest and leasehold interest must be merged or put under the control of the same person. That means at the end of the day, the person who was the tenant will be the sole owner of the property. That's what we mean by merger. That is very, very important. So that's basically what I had for you with respect to termination of leases. And I wish to encourage you to subscribe to my channel, share with friends, and comment. When you comment, I will also be guided on where you need clarification, on where you need maybe you may find you need some video, let's say in jurisprudence, in intellectual property, in family, in evidence, or even in introduction to law. So leave your comment. I will actually come read your comments, then I will do the necessary. Thank you so much. Bye bye.